RFO, and the clerk of the court says, well, you can hear that, we can hear that in 60 days. Court's busy, calendars are full, but you may not need the order that day, but you'd like to have it within a week to 10 days, not 60. Days. What do you do?
That's called shortening time, request for shortening time. Again, every RFO goes with a declaration and reasoning. And if you're going in ex parte, you need points and authorities. That's the only time you need points and authorities. You can run to court and say, Judge, I know it's not an ex parte. I know it's not an emergency, right? But I can't wait 3 weeks. So give me a date earlier. Like what? Like, let's say I'm at home and I have no access to any funds, okay? And my house, I got notice my house is being foreclosed. And there's an auction in 5 days. And all the funds are in my spouse's possession, right? Now, I have 5 days to cure this late payment or I'm going to lose my house, right? So it is an emergency because if my house goes to auction, I have no way of getting it back. Well, at least not easy to get it back. Let's just put it that way. I will file my ex parte notice to court and I will ask for what I need, the funds, the payment. And then I'm going to ask, okay, Judge, I know money is not an emergency. In the alternative, shorten my hearing so you can hear me before my house gets auctioned. And that's request for shortening time.
Okay. So let's get back to the type of RFO. Let's assume now for a moment that your RFO is for or includes types of child support and spousal support. What do you have to do to prevail or defend against that type of RFO?
Okay. Every request that has money aspects to it, whether it's child support, spousal support, attorney's fees, basically these three, it has to be accompanied by a form called income and expense declaration. Income and expense declaration, it's a form that asks you a lot of questions. How old are you? Where do you work? How much do you get paid? What kind of deduction you have? Who do you live with? What's your rent or mortgage? What's your insurance payment? A lot of information which is personal to you. Mm-hmm. That has to get filed at the same time that you file your papers. Now, once you file it and you have a court date, you serve all of this to the other side. So the other side gets to look at what you have. And the other side prepares his or her income and expense declaration and declaration regarding the request. Then there's a court hearing. At that court, again, if you want to bring in witnesses or if you want to put the parties on the stand, you need to advance notice the court saying, I intend to do this, Judge, give me enough time. Then you get to question at the time of the hearing, you need to question the other side. It is extremely important how you prepare your income and expense declaration, because if you are showing $1,000 a month income, but $5,000 expenses, the court could actually impute the $5,000 expenses as your income for the purpose of calculating support. So how do supports get calculated? Once we have the numbers, there is a program called DissoMaster, which is a guidance to what how much support should be. It's a guidance, especially on the temporary support for spousal support, but definitely gets used for child support. So the judge uses those numbers, plugs in those numbers, and a number pops out as, you know, how much you have custody, how much insurance you pay, what's your income, what percentage you have custody. Then it gets calculated into this program, and the program gives you a number, and the judge uses it as an order. That's how we get the child support. Spousal support is a little different. Spousal support, supposedly, it should be the guidance. But normally for the temporary spousal support, DissoMaster is used. But at the end of the case, when, let's say it's a long-term marriage, when the case is over, they will not use DissoMaster to calculate how much support should be awarded to the, let's say, not working spouse. The guideline is only used for the temporary support.
You know, if the guideline amount in the DissoMaster spits out a number, let's say for child support, is there any law that I could argue if I was the dad, you know, who was the high income earner, to say, hey, you know, paying her $20,000 a month is just ridiculous?
I had a case and I represented an actor. And this actor just had a brand new baby and a brand new divorce. So the guideline was showing something like $500,000 a month child support. So we knew that a child of a newborn does not need $500,000 a month. Okay. And we went through all of that argument. Dad was arguing that a brand new baby does not need $500,000 to support, because their lifestyle at that point wasn't even that extravagant as someone who was making millions a month. Court had us hire an economist. And the economist did some calculation based on the lifestyle of mom and lifestyle of dad, and came up with a number to maintain mom's lifestyle for this child as it was while mom was living with the dad. What's the right number? Does the judge have the power to modify the child support? Yes, it's a guidance. It's a guidance. It's given, basically the number is given so people won't run to state seeking help. So yes, the judge has the authority to change it. Parties may agree to a number higher than the guideline or the lower. Parties can do that too, as long as they don't fall within the need of the county to help them.
In your practice, have you seen the judge deviate very much from the guideline support?
Not for child support. Not for child support. I mean, if it was a very, very high earner, yes, I've seen it. But we're in LA, and the standard is a lot higher than other places. We have Hollywood, we have, so it's like if you say somebody's making $1 million a year, it's not as big of a deal in Los Angeles as it is in other states. So it doesn't happen often here unless, the guy's making $1 million a week.
When you became a judge, a temporary judge, did they send you to any type of training regarding these issues?
Not on these issues, but a lot of ethical issues.
Okay.
it was more ethical issues, but the classes they had was more ethical, how to take the matter under submission or uh, you know, allow the person talk, but if they they going a little bit angry, give them a break, let them go outside, recall the case. A lot about prejudice, a lot about prejudice. But again, all of these cases, we get trained regardless of going on the bench or not. We get trained, we take classes. It feels like my schooling is never over because we need to take classes, we need to take seminars. I'm sure you know, it's just not one day. I have seminar every Wednesday of a first Wednesday of the month. It's a new cases come out. We're practicing. We don't know it all. We're gonna learn it one day.
Right.
We're practicing it.
Somebody once told me, being a lawyer, I mean, after you practice a few years, you get the hang of it, but it takes you a lifetime to master.
That is true. At the beginning of my practice, my God, it feels like a million years ago. It was like 23 years ago. You want to be heard. You want to say it. You loud. You just want to say it. You just want to say it. You want the judge here. Judge, hear me. Let me tell you. Let me tell you. As time goes on, you listen more. And then you sit back and say, oh, that's a new attorney. He wants to be heard. So yeah, there is a mastering about it. Time does help.